So hello everyone. Our group will be conducting a case review of the topic strike out pleading. The case is Hap Seng Consolidated Bhd and Darinsok bin Pangiran Apan and others. It is about the civil procedural matter in regarding of our topic, the strike out pleading. So the application of the strike out pleading can be found in Order 80, Rule 19 in the Rule of Court 2012. But then, in this case, the rule will be using is in the Rule of Court 1980. Okay. The application for the rule for the strike out pleading is have some circumstances. The first one is that if there any reasonable cause found by the being claimed by the any party of the case and the court found it reasonable, then they can do so. The next one is if the claim be made seem to be scandalous or has the bad intention for the either party. The next one is the case been heard before the court will leave a negative connotation of the judicial system. The public will deem it as unworthy and doesn't give a good view. The last one, the court will grant the strike out pleading if the case been heard before it is abusing the court process.
Hello, Assalamualaikum. I'm SAKINA SOLIHA binti MAZDEE SHAM 256023. I'm going to talk about the facts of the case, but before that, I will introduce the parties to the case. The appellant in this case is Hap Seng Consolidated Bhd, while the respondent is Darinsok bin Pangiran Apan. An action was first brought by the respondent in this case, which is Darinsok, over the title of the disputed land in the Tanggol region. They have been continuously applying for the title over the land from the Director of the Department of Land and Survey Sabah from 1985 to 1999, but failed. However, in 1997, the Director of Land and Survey Department had approved appellant's application for the country lease over the land, which eventually the land was alienated to the appellant. 2 years later, the title of appellant over the land was issued in the country lease. Then, the appellant cleared the said land and grow oil palms on the land. Not just that, on 3rd May 2012, appellant had sold and transferred the title of the land to Tanjung Bahagia Sendirian Bhd. After hearing the news, respondent applied for 17 declaratory and injunctive reliefs and damages from the court. Judgment was given in favor of the respondents. This is why the appellant appealed to the Court of Appeal. Since appellant's arguments were rejected by the Deputy Registrar, appellant applied for summons in chamber to strike off the previous decision. Appellant also claimed that the High Court had no original jurisdiction to hear the respondent's claim. At first, the JC allowed appellant's preliminary objections against respondent's application for injunction. As a result, the respondent's claim was accordingly dismissed. The respondent then appealed to the Court of Appeal but was dismissed, so the respondents proceeded to federal court where the appeal was allowed. Respondent's suit was then reinstated and remitted in the High Court. In the High Court, both of the appellant's appeal were dismissed with cause. Thus, the appellant's application to strike off respondent's action was refused by court. Thank you.
Hello, my name is NURIN binti Ahmad SOBRI, matric number 255872, and I will present the judgment of this case. So in this case, it was held that the court dismissed the two appeals by the defendants to strike out pleadings by the plaintiff under Order 18, Rules 19, Subsection 1 of the Rule of High Court 1980. There are some reasons for that. So the first one is that the rules provide 4 grounds to strike out a pleading, but then the court found out that the facts and circumstances of this case was not fit to the grounds. And also the court viewed that this case is related to plaintiff constitutional rights and also common law rights compared to defendant's claim, which is the jurisdiction of the court. And the last reason is that the court believed that High Court decision was right in dismissing the defendant's application to strike out pleadings, as it was affirmed by the Federal Court decision, which shows the correctness of High Court decision, and also it was beyond question. Thank you.
Hi, I will be presenting the issues for this case. So there are two issues in this case. The first issue is whether the judge has the right in rejecting the striking out application. And the second issue is whether the action was frivolous, vexatious, or abuse of court process.
My name is Siti NURUL ARUSHA 252729, and the analysis of this case review had found out the Order 18, Rule 19 of the Court 1980 was filed against the respondents who was seeking injunctive reliefs and damages against the appellants, whereas a striking out application will only strike out a writ and statement of claim when it was obvious the action could not be sustained, either no reasonable action or defense under the Order 18, Rule 19. The case application for striking out application could be portrayed in Bandar Builders Sdn Bhd and others against United Marine Banking Corporation in 1993, where the court held that the counterclaim and the defense to counterclaim disclosed no reasonable cause of action or defense that raised some question fit to be decided by the judge, and pleading should only be struck out if it is shown that it is obviously unsustainable. In this case, analysis 2 had found out that the appellant contended the High Court had no jurisdiction to hear the claims raised by the respondent, whereas the jurisdiction to hear the claims only conferred upon the collector. According to Sabah Land Ordinance, it is a duty of collector to inquiry and to decide claims upon native customary rights. However, the collector had contravened the jurisdiction conferred upon him, as according to Section 14 of the Sabah Land Ordinance, when he contravened the jurisdiction and alienated the land in dispute to the first defendants, when he could only determine the native customary rights and not acting vice versa. The action of the appellants was wrongful, as the said land was being deprived from the native livelihood, and there is also the issue in discrimination in compensation, and the court had dismissed the appeal by the appellants on the grounds that this issue was relating to the respondents' constitutional rights and common law rights in regards of the native customary right. In this analysis, we would gladly to know that the proceeding in Malaysian court also acknowledged the rights of indigenous peoples over rights to lands, which could be portrayed through the Commonwealth case in Mabo against Queensland, whereby the Privy Council held that it will assume the Crown's intends the rights of property of the native are to be fully respected, and the Crown's rights or interest is subject to any native rights over such land, which is the Crown and its successors only obtain the radical title but not the absolute beneficial ownership of the lands. It is successfully laid down that the common law developments and on indigenous people without formal recognition has the same effect as written law and comes within the meaning of existing law. In this case, the respondents allege that the ancestors had settled as native communities in the region prior to the enactment of the Land Ordinance, which is, in addition, a system of land tenure was existed in Borneo, most known as the term of adat. For instance, in the case of Nur Anak Nyawa and others against Borneo Pulp Plantation, Sdn Bhd, when the court dismissed the objection as they found the Ibans already had a a body of customs as to the native customary rights. In the present case, it is sued with the respondent contention stated there was already pre-existing customary laws acquired by their ancestors before the formation of colonial North Borneo, which is, we could say that it is not a proper action to strike out the respondent's pleadings based on the appellant contentions on the grounds that the issue was relating to the constitutional rights and common law rights.
Assalamualaikum warahmatullahi wabarakatuh, and I wish a very good day to everyone. My name is AMIRA HUSNA and I will present regarding the final part of our assignment. I will talk about the plaintiff pleading. Plaintiff is the respondent in our case, and this plaintiff had the locus standi of their claim against the appellant, which is the defendant in the previous case. And because of that, the court was right to refuse the striking out application against the defendant, because in the court finding there were a lot of tribal issues in the plaintiff pleading, so the plaintiff pleading is were good enough to be tried by the court itself. And moving on to the judgment delivered in this case were right and just, because the application of striking out of any written statement of claim will only be succeed unless there is a indisputable issues and liable to be struck out under the law. Furthermore, the plaintiff constitutional and common law right were there, and there should also be no problem if the court want to refuse the striking out application against the defendant. Moving on to the provision used in this case, which is the Order 18, Rule 19, Subsection 1 of the Rule of High Court 1980, which stated that any counterclaim or defense to counterclaim cannot be struck out unless there had been obviously unbearable issues, where it can be a striking out application cannot be succeed, as the striking out application cannot be simple used by the defendant or any disputing parties as a shield in order to protect themselves to be irresponsible for their own wrongdoing. Therefore, my final word is a court must ensure that there should be a valid reason before entertaining any striking out application applied by any parties, because there always is something that or issues that can be tried or can be upheld in order to achieve justice by the court. Okay, that's all from me. Thank you.